Your business partner has legal weapons pointed at you right now that you probably don't even know existed. I'm Karam Nahas. I've spent 20 years in courtrooms watching partnerships explode into fraud cases and fiduciary duty lawsuits. I've represented partners on both sides of these battles, and I've seen entrepreneurs literally lose everything because they didn't understand the legal duties they owed each other. So here's what most lawyers won't tell you, or they don't even know. The moment that you become business partners, the law automatically creates powerful legal obligations between you, whether or not you wrote them down. So today I'm going to break down exactly what partnership duties you owe one another, what fiduciary duties can destroy your business, and the most commonly violated duties that turn partnership disputes into felony accusations. Because if you don't understand these duties, your partner's lawyer will use them to bury you, and I've done that to others, so let's get into it. Here's what they don't teach you in business school. Partnership law operates on two levels. Level one are implied duties. The moment you become business partners, whether it's an LLC, partnership, or an informal business relationship, the law automatically implies certain fiduciary duties between you. These exist whether you want them or not, whether you wrote them down or not, whether you even know about them or not. Think of these as the invisible legal chains that bind every business partnership. They're designed to prevent partners from screwing over each other. Then there's level two duties. Those are express duties. These are the duties you actually write down in your partnership agreement, your operating agreement, or corporate bylaws. The stuff you negotiate and agree to explicitly. Here's the problem though. If you don't have written agreements, you default to your state's limited liability statutes. And trust me, those default provisions are not written to protect you. They're written to prevent chaos when partnerships blow up. So what's the legal reality? Most entrepreneurs think they can just figure it out as they go. Wrong. The law has already figured it out for you, and if you don't like what the law decided, you better decide it yourself, put it in writing, decide your own fate. That's what I always tell my clients. So what are the three duties that are going to destroy you in a partnership? Duty number one is the duty of loyalty. This is the big one. The duty of loyalty means you cannot put your personal interests ahead of the partnership interest. What it means in practice is you can't compete with your own partnership. You can't steal business opportunities that belong to the partnership, and I've seen a lot of that. You can't have conflicts of interest without full disclosure, and you can't self-deal without partner approval, and that happens all the time. So how do partners violate this? Now, I see partners get sued for taking on side clients in the same industry, for hiring family members without disclosure, for investing in competing businesses, and for keeping information about opportunities to themselves and giving it to someone else and profiting indirectly. Now, the duty of loyalty doesn't care about your intentions. It only cares about your actual actions. What's the second big duty? The duty of care. That means you have to manage the partnership's business with the same care that you'd use for your own affairs. So you can't be reckless, negligent, grossly incompetent, whatever. So how does this look like in practice? You have to make decisions that are informed. You can't ignore obvious risks to the business. You have to maintain reasonable business records. You can't make major decisions without proper due diligence. You have to cover your ass when it comes to business decisions. So how have I seen partners violate this? I've seen the duty of care violated by partners who sign contracts that they don't even read or understand, or who fail to maintain insurance, who ignore obvious compliance issues, or who made major financial decisions based on gut instead of actual analysis, experts, or sharing with other partners. Due diligence and full disclosure is a must when it comes to partnership. So the duty of care means that you can't just wing it, right? You have to be professional about running the business. So duty number three is a big one. It's the duty of disclosure. This one's simple, but it's deadly. You have to tell your partners everything material about the business. You can't hide information even if it makes you look bad. And the word material is a legal term that has so many meanings. So what does this mean in practice? You have to share all financial information. You have to disclose all conflicts of interest. You have to reveal problems with clients, vendors, or operations, and you can't keep secrets about anything that affects a partnership. That could be personal issues. So how have I seen partners violate this? I've seen disclosure violations for partners who hid client complaints, right? Who didn't report cash flow problems, who failed to disclose personal relationships with vendors, or potential liabilities that they incur, or kept separate books for part of the business. Believe me, business partners do all sorts of shady shit, and I've seen a lot of it. So the duty of disclosure means there can be no secrets when it comes to your business partner. Even the most uncomfortable secrets need to be shared. That's my opinion. So those are the biggest duties that you have to know. So how are they violated? The biggest violations I've seen are unauthorized use of partnership funds. This kills more partnerships than anything else. Every time you spend partnership money without proper authorization, you're violating your fiduciary duty. So what's the trap? Most partners think, I'm the owner, I can spend the money as I see fit. That's wrong. Unless your agreement says otherwise, major expenses require mutual consent. I put that in every agreement. The only way to protect this is to set spending limits in writing. Anything over 10,000, let's say, requires both signatures. Keep receipts for everything. Document the business for every expense. Believe me, it will save your ass one day. So the second most common violation I've seen way too often, that's when one partner takes a partnership opportunity for themselves, or they send it to a third party and they get paid indirectly. This is the corporate opportunity doctrine. And if an opportunity comes to you because of your role in a partnership, it belongs to the partnership, not to you personally. Don't take it. The trap here is when a client offers you a side project, you think, well, this is separate from my main business. No one will find out, right? Well, your partner's lawyer will find out if they're any good, and they're gonna argue that you stole a partnership opportunity, and you're gonna lose. So the way to do this is to offer every opportunity to the partnership first. If they don't want it, get a written declination if they don't want it. Document that and disclose it fully. Now, the third most common violation that I see of fiduciary duties is the self-dealing without full disclosure. Anytime you benefit personally from a partnership decision, you need full disclosure and approval. So you hire your cousin as a contractor, use a vendor owned by your friend, you lease office space from your spouse. Even if these are good business decisions and you're getting a great deal, it's still self-dealing if you don't disclose the relationship, and that can undo a lot of opportunities. The protection here is to disclose every personal relationship that touches the business. Get written approval for any transaction where you benefit personally, and document that the terms are fair market value. So here's what you need to understand about fiduciary duties. They're not suggestions. They're legal obligations with serious consequences. Violate them and your partner can sue you for damages, profits, attorney fees, in some cases, punitive damages. And in my agreements, I take equity away from bad partners. But here's the good news. These duties work both ways, so your partner owes them to you as well. And if you understand them, you can use them to protect yourself and hold your partner accountable, because like I tell you, partners can become your biggest enemy. The solution isn't to be paranoid about every decision, it's to be professional about your partnership. Get proper agreements in place. Trust me, that's what it's all about. Document your decisions, disclose your conflicts, follow the rules, do compliance, learn about it, because the alternatives isn't just a bad partnership, it's a fiduciary duty lawsuit that can destroy your business and your personal assets. So now that you understand fiduciary duties, you really need to understand how to bulletproof your partnership agreement and get an understanding of the type of provisions that I put into partnership agreements to make sure that you're legally protected. That's the next video I'm recommending, how to legally bulletproof your partnership agreement. I'll see you there. I'm Karam. Stay legally bulletproof. I really hope that you enjoyed this video, but if you're sick of guessing whether your business is exposed to legal threats you can't see or didn't know was coming, those enemies, mistakes, and liability that cause entrepreneurs to lose, then I've got something very special for you. It's my free business risk report, the same kind of analysis I charge $7,500 for in person when I do my business defense legal mastermind. Click the link below, answer some strategic questions about your business, and get a personalized risk report. You've got nothing to lose. Find out what's hunting you and your business before it destroys everything you've built. I'm Karam, the battle-tested lawyer. Stay legally bulletproof, please.